said, I worked full-time.
You were full-time
At Harlan Hart, yeah.
Wow.
Because, and I think in some ways it's better.
Yeah.
Because you don't obsess about it, I mean.
And I guess if I fail, it's not the end of the world because I could just take it again later.
You're not going to fail. You're not going to fail because of working part-time.
Okay.
No. I mean, if you don't want to do it, if you think it's going to be a miserable experience, I think that's different.
I mean, I think it would be fine, but
I think the
this
other
is just
people
happening
around
today,
you,
so I'm a little nervous.
the other people around you who are studying full-time are going to be more miserable because that's all they're going to be thinking about.
Well, and I also kind of like the idea of not being here all the time because I remember when when everybody's all freaked out and you're comparing yourself to the other everybody around you and you're really nerving and you totally don't need to nerve and
Never heard that.
I heard that
before. That's good.
So I also think that would be good to avoid.
Also,
I'm
sorry.
not the kind of person who can deal with other people being frantic.
Well, I get frantic.
Yeah.
I
don't think. I don't think it puts you at any risk.
Okay.
I mean, like I said, for some people who don't have their study habits together, it's kind of different, but just sit with it.
Yeah. It won't be too bad.
Well, demographics.
No, it won't.
But I also, when he suggested that, he was I think that would be a really great way to do it, and blah, blah, blah. And I was like,
Demographics.
I don't want to wait to take the bar.
It'd work great for him.
Yeah. No, he didn't do it.
Oh, well, for him to have.
I think
As far
that's
as-
torture. I think that's torture. I think you want to just get it done with.
Okay.
And that's, just wait.
Okay. Talk me out of that.
Well, I just think my perspective is a little different. So I kind of want to wait for Will, but I don't know, is it missing Jose?
He said he has that class and he might come a few minutes late, right?
Okay, that's right, thank you.
Here you go, Kira.
Oh, thank you.
All right, so really good conversation on Monday, and I think our conversations are just going to keep getting better as we dive into substantive material here. So we're reading, why are we reading Plessy and Bowers right now? I mean, obviously it's giving us some introduction to equal protection doctrine, but what's kind of the point of reading it on the heels of talking about ethical judicial opinions?
Because they're known as being wrongly decided.
Yeah, they're known as being wrongly decided, and again, it's kind of a question of what happened, right? What happened? I mean, is it just, these judges are racist, or these judges are homophobic, or whatever? Or is there something more sort of process-oriented that we can identify? Some sort of transcendent principle for avoiding issuing decisions that are later seen as being, very problematic. So I wanted to just wrap up on ethical judicial opinion writing with this little worksheet here and just talking about some of the stylistic considerations. So we talked about what makes for an ethical judicial opinion. We talked some about the pure and impure styles of judicial opinions. And this is sort of a checklist of things you might want to think about as you're drafting an opinion, either in the class or when you start up your clerkship. So the length of the opinion, what is your general impression about the length of judicial opinions, whether that's something that is, given a lot of thought or not?
Doesn't that depend on what issues you're addressing?
It should, right? So if you actually have a lot of issues, and if those issues are fairly complex, you have a lengthy factual background that you need to provide, obviously that's going to influence the length. When is it problematic to have a long opinion?
Always.
Yeah. I mean, when the content doesn't dictate it, right? So, I mean, I think that especially regulatory decisions, review of regulatory decisions, statutory issues can get really, really complicated. But a lot of decisions could be decided much more concisely. You think about some of the great decisions like Brown versus Board of Education. I think that's under 10 pages, right? Loving versus Virginia as well. So, on the one hand, you want to provide an adequate explanation for the decision that's reached in the opinion, but the sort of verbal diarrhea syndrome is just not, it's not doing anyone any good, and it reduces the accessibility of the opinion. Issues. What issues do you need to include, you want to include in your opinion? So you have choices about that. Some choices.
Just positive?
Just positive, right? You should. I mean, if there's one issue, so like we talked about, just positive means that one issue will, eliminate the need to look at other issues. Obviously, you want to look at that and probably look at that first. What else?
Wouldn't threshold issues be in there as well?
Yeah, right. You have to start with the threshold issues. So level of scrutiny, standard of review, standing. So we saw this happen with the United States Supreme Court with both the DOMA litigation and the Prop 8 litigation, that the court certiorari was sought on the merits, but the court asked both sides to brief the issue of standing, and in fact brought in special counsel to file an amicus brief on the issue of standing. So obviously, if you don't have standing, end of the story, right? What else?
I have a question about that. The standing, that can be brought like sua sponte by the court, right?
Absolutely, because it goes to their Article 3 jurisdiction.
Okay.
Right? So you can't, if there's a ripeness issue or standing issue, the court really it's not legitimate for the court to go forward, so they can bring it up sua sponte. Is everybody familiar with that idea of sua sponte? It's something the court brings up that the parties have not brought up. What else about issues? What's important in terms of an ethical judicial opinion?
I think the reading said to address the biggest issues first.
Yeah, so there's the reading said that to address the constitutional issues first, which I actually disagree with. There's doctrine that sort of counsels against that approach generally. I mean, it depends on the circumstances, but what am I referring to?
Constitutional avoidance.
Yes, constitutional avoidance. Okay, so if a court can decide a case on non-constitutional grounds without interpreting the Constitution, they should do so. Okay. But yeah, you wouldn't want to start with the most if there's not a necessary sequence suggested by the analysis, you wouldn't want to start with the sort of minute issue and leave the more important issues toward the end. But the other point I'm getting at, you have to address all the arguments raised by the parties. Okay. In one way or another. You could do that in a very summary form, but even when you get that pro se, habeas petition, you have to address everything that's brought up in there one way or another. And there are ways to deal with, to condense several issues together and what have you, because as I mentioned, that's really the basis for a motion for rehearing. Okay, not that you decided the issue in a way that the parties didn't like, or one of the parties didn't like, but that you failed to discuss the issue altogether. Okay, so it's your responsibility to make sure, and you likely will be more familiar with the briefs and the record than the judge. It's your responsibility to make sure that all the issues get addressed. Okay, and then we talked about in what order to address the issues. Obviously, preferring threshold and dispositive issues when those are presented. Okay, what are your choices in framing the issue? And this Bauer versus Hardwick is absolutely a critical lesson in this exercise. But what kind of choices do you have in framing the issue?
You could frame them as the parties.
Okay, right, so you could accept the framing by the parties?
Narrow or broad?
Yeah, narrow or broad, basically, right? What should courts prefer under a sort of ethos of judicial restraint? Narrow, okay, but are there sometimes problems with that? Yes, okay, we see that in Bowers versus Hardwick, that there are, I think, really serious substantive implications sometimes from framing issue too narrowly and also from framing the issue too broadly. So just recognize there's a meaningful decision to be made there. Discussion of the facts. What do you all anticipate when you think about discussing the facts in a judicial opinion that you're drafting?
Like neutral reporting? Is that what? Well,
do you feel like that's true when you read these opinions?
Well, I think that if you're arguing for a certain, it kind of depends on your approach, right? So
yeah.
If you're arguing for a certain result, then you want the facts to be framed around your result.
Mm-hmm, mm-hmm. So this goes back to the question of whether judicial opinions are objective or persuasive writing.
Yeah.
And, they're kind of in between in a sense, because they're not taking a position for one party or the other, but they are taking a position in terms of the correct outcome in the case. So one way of thinking about it is that when you read the facts, you should maybe already be able to tell which way the court's going to go, right? Even if they haven't broadcast their conclusion yet. But that being said, I mean, that's a great skill for your brief writing, right? Is to present the facts in such a way that the court is already kind of nodding its head and going along with you in terms of the way you're going to present the legal argument. For a court, you can't be excessively one-sided. And the article talks about this, but you need to acknowledge contrary precedent, and you need to acknowledge contrary facts or facts that are problematic for your analysis. Okay, so this is really, advocates have a duty of candor as well, but it's really, I think, more pressing for the courts, right? So if we expect an advocate maybe to downplay a particular factual issue or precedent or something like that, but for the courts to do so is of greater concern.
Going to that, one of our bar prep classes, like the opinion, or one of the cases in our bar prep class, the opinion kind of said, the judge, it was a bench trial, and like the judge kind of said like there was this testimony given, which we disregarded as like not the truth, and then they went with,
not credible. Okay.
Yeah, not credible, and they went with the 5-year-old's version of the facts.
Okay.
And then kind of just presented, it was all one-sided basically based on what this one witness had given.
Well, that's interesting. Did you talk about that as being problematic, or?
No, not in that class.
Yeah.
I mean, that we're just trying to pull it through.
Yeah, okay. So that intersects with another issue which is relevant for trial courts, which is credibility determination. It's also relevant for appellate courts because who's the expert on credibility determinations?
Trial court.
The trial court, right, and the jury, if there's a jury present. So it's appropriate for the trial court to make a credibility determination, but sort of, to what extent does the court have to explicitly defend that credibility determination, and is it appropriate to absolutely strike the entire content of the testimony of the witness who's not credible? Maybe, maybe not. In a sense,
does it make it harder to overturn?
Well, credibility determinations are really out of the reach of the appellate courts,
right?
Right. So it's actually a very smart move to make an explicit finding vis-a-vis credibility, because that brings it really into the territory of the trial court's expertise. And we'll see a little bit of that going on when we look at the district court opinion in the Perry case. I think from your description of it, that's completely appropriate, the way that the court approached it, but you can sort of see that there's some concern there, right, that you're essentially taking away the other side of the story, and is that credibility determination well-founded? But that is one of the most powerful sort of realms of decision-making that the trial court has. Okay. Talking about cases, you guys have been writing about cases, you've been reading cases since the first day of law school, in some cases a few days before the first day of law school. How do you talk about cases? How do you write about cases, in your opinion? Very open-ended question.
Compare them, contrast them.
Okay, so compare and contrast, that's something you do with them kind of after you've described them, right?
Right.
There's an important line in the Ethical Judicial Opinion Writing article, which I agree strongly with, is that you write about the law, you don't write about cases. There's some exceptions, right? So in constitutional law, a lot of times the cases are so significant that you're actually writing, sort of a description of the case as well as the law. But the cases are important not because sort of inherently important because they exist. They're important because they tell us what the law is. Okay, and if this maybe is a skill you haven't practiced a ton up until this point, or something you've struggled with, it's something we're really going to want to work on for purposes of writing the judicial opinion here. Okay, that you talk about legal issues and you talk about rules of law, and you don't talk about cases. You don't organize your analysis by case, so to speak. Okay.
But then you might have a key case where you're going through tons of facts on the case, but.
So, for example, we were talking about this. I was asking you if there was a particular way you were thinking about going and writing the opinion. But let's say someone like the Ninth Circuit did in Perry, really wanted to lash themselves to the mast of Romer versus Evans, right? You're going to talk a lot about Romer versus Evans. You're not just going to state a rule of law and then cite to it. Other cases, other decisions that are just referring to Romer for a particular proposition will do exactly that. You know, there's language from Romer that's quoted all the time, and they'll just quote that and you know, have a citation afterward. But if you're going to draw a lengthy analog to a particular piece of precedent, you're going to talk about that case as a case in a sense, but always from a legal perspective. And so that has to do with, we'll talk a lot about topic sentences in drafting your judicial opinion for this class. So the topic sentence is the difference between saying the United States Supreme Court decided Romer versus Evans in 1996. It tells you nothing, right? It tells you nothing about why you're even bringing up this case, right? Versus, you know, in Romer versus Evans, the United States Supreme Court concluded that a bare desire to harm homosexuals was not a permissible basis for legislation or what have you, okay? So even when you are giving a case a lengthy treatment, you always want to do so from the starting point of its legal significance for the case at hand, okay? And same thing, like I said, with the facts, with the cases, you need to, boy, I mean, this is, you know, actually a question you can spend some time on, but really characterize the case fairly, even if there are portions of it that are not favorable, or even if it's not as clearly in support of the contention that you want to make as you would like, okay? And that's an ethical issue for practitioners. I mean, I've had occasions of reading briefs and the attorney's going to assert that a certain case stands for a certain proposition, and I know that case. And I go and I look at the citation, the case doesn't say that. That's a big deal. That's not just, you know, playing fast and loose with the law. That's, you know, potentially an ethical violation. We talked a little bit about when you're in the position to come up with a rule of law yourself. And the...
That's scary just to hear.
It's wonderful. You should be thrilled, right? You should be thrilled about that idea. You know, a great example, this, you know, like in the state courts, like it's a tort claim, right? So an issue of first impression, is there a new type of tort claim that's being brought, or, you know, a certain variation on a theme, and you're looking at how our sister jurisdictions have treated this particular issue, assembling all of that information, and then synthesizing it into a rule that's going to be applied in Colorado, okay? But the, you know, we talk about the importance of crafting a rule for all time, right? Just recognizing that you're not just resolving this one dispute, you really need to think about, as much as you can, the consequences of applying that rule going forward. And, you know, is it assuming too much? Is it too narrow? Is it too precise to really be able to be applicable to future cases? Or is it so vague, is it this sort of broad platitude that it provides no guidance whatsoever? Okay.
How much deference does a federal court give to like a state Supreme Court?
On what issue? That's it depends, right? On what issue?
If it's like a tort issue or...
Yeah, so if you have a tort issue, I mean, it really should be full deference, right? I mean,
Okay.
the, you know, state tort law is defined by the state courts.
So it's issue determinative?
Mhm.
Well, I mean, if it's a federal issue, then yeah, you shouldn't really give much deference.
No, but that's exactly right. It's sort of discerning, you know, when you have diversity jurisdiction, what are the federal issues, what are the state law issues, and then you have the federal courts in the position of trying to anticipate or predict how state courts would operate. Okay. But yeah, I mean, just keep in mind that courts, whether it's, you know, within the federal system from trial to appellate, or state versus federal courts, that each court has its sort of area of expertise that is going to influence the way that other courts treat decisions in that area. Okay. Clarity in writing. We will work a lot on this. We'll do some exercises on this, but basic principles: avoid legalese, use plain language, clear, focused sentences. Basically, the opposite of everything you read your first year in law school. Clear focus sentences, clear focus paragraphs. Avoid throat clearing and meta disclosure. You now I'm going to talk about, there's a difference between signposting and road mapping versus, basically excess verbiage. I mean, we'll do a writing exercise and we're going to eliminate every unnecessary word in a particular passage, right? You want to, I edit for that, but ideally you can write that way in the first place. Get to the point where you're writing that way in the first place. Taking care in using quotations, avoiding block quotes, and if you are going to use a block quote, to present it in a way that brings the reader into it, right? This is why, essentially you're conveying this is why I'm providing this block quote. But block quotes typically indicate sort of laziness, like I didn't, want to restate this or digest it or tell you what it means. Okay. Okay. So any questions? It's just sort of like a checklist, a sort of brainstorming tool to think about, issues, stylistic issues that will be important to you in opinion writing. Any questions about that? Okay. Great. We're going to obviously revisit these issues quite a bit. So let's talk, we touched on both Plessy and Bowers a little bit last class, but now we're going to do it in a more systematic way. So let's talk a little bit about the Plessy decision, and then we'll move on to the Bowers decision. Who's the plaintiff in Plessy? Plessy.
I mean, I don't think they say this in the opinion, but I think I just know from sometime in my schooling
Yes.
that he looked white, but he
It is in there, it is in there.
Okay.
Yep.
7/8 white.
7/8,
Yeah.
right, yeah. So I guess what they didn't talk about the opinion that I was remembering was, did they identify him as colored by his card or something that said it, or?
So, I have not read this book, but there's either a book or an article kind of about the factual background here, and let's speculate first, okay? So what could have happened? So the presence of African blood was not discernible in him, or whatever. Can you find this phrase actually that they use in the fact recitation? So he looks white. That's basically the upshot, right? So how did it come to be that he was identified as quote unquote being in the wrong coach?
Mixture of colored blood is not discernible.
You have it?
Yeah, that's just almost exactly what you said, that the mixture of colored blood was not discernible
Okay.
in the proportion of 7/8 Caucasian and 1/8 African blood.
Okay. Very precise measures there. So what could have happened?
I kind of envision this just not having known some of the background facts as like maybe running into someone he knew who happened to know like who his grandmother was.
Okay. So maybe just a small community and people knew, he looks white, sure, but actually, in actuality, whatever that means, he's black. What else?
What were you saying about it? There were like ID cards or something? Is that what you were
I
saying?
don't know if I made that up. Yeah, like conflating like something else.
Yeah, I've never heard that, particular idea, but, you could imagine maybe there might be some documentation and they're showing your documentation to the conductor or whatever, but what else?
It was a test case?
Yeah, it's a test case, okay, so tell me, why does that make a difference if it's a test case?
What do you mean?
When you
If
say
they
it's a
wanted to
test,
challenge
okay, yeah, right. So the idea is with civil rights litigation, you're probably talking about this in Professor Chen's class. I don't know.
Mm-hmm.
You need a plaintiff, right? You need a plaintiff. You need someone who's actually affected by this law, and you don't want to just sort of wait until somebody decides to enforce it, right? So you might actually create the circumstances that would allow you to test the law. Okay. So that's plaintiff. Who's the defendant? Who is the defendant?
Judge of the criminal district court.
Okay, is that interesting at all to you? Does the judge? Why is the judge? What type of action is this?
So the habeas corpus?
No.
It's this.
Can't be a 1983 then.
Nope.
Why isn't the judge immediate?
Well, they're not seeking damages. Okay. It's a writ of prohibition in this case.
Just to prevent enforcement of the criminal statute, is that what it?
So a writ of mandamus or a writ of prohibition, I mean, sometimes you'll have a writ of mandamus where, for example, let's say a trial court judge has delayed a year in issuing a judgment. And so you are, essentially what you're doing is you're calling upon another court to tell this judge what to do in this particular case. So it's really not, it's just a very different type of action, right? So here, it's a way of getting at the constitutional merits of the law that the judge is enforcing, right, by convicting Plessy of having violated this statute. But it's, it's a different vehicle where the judge himself or herself is actually the defendant. Okay.
But how, I mean, I guess procedurally, how does that work? Is it before he was he was convicted, right?
Right, so then it's a matter of...
Wouldn't it become the executive who's in charge of enforcing? I mean, after the judge decides that he had violated the law.
Let's see exactly what was the sort of last step in the procedural posture prior to the filing of the writ of prohibition.
This was a petition for writs of prohibition, certiorari, originally filed in the Supreme Court. So is what he's trying to do here, he was convicted by the state Supreme Court, and now he's trying to have another court disallow the state Supreme Court from doing that?
Disallow the trial court, the criminal court judge, yep.
From convicting him.
Yeah.
So, it makes it seem like the timing must have been pretty quick in order to...
Yeah, well, it's sort of like an emergency, type of an emergency writ. Go ahead.
So he's not challenging the constitutionality of his conviction itself. He's challenging, like, he's not, because what
He's
you usually do is you would be
statute.
Yeah, but you would usually be convicted and then you would appeal. But he's not doing that. He's saying this shouldn't even be a crime. Okay.
Yeah, and so essentially the judge, the trial court judge, the criminal court judge doesn't have the authority to convict him under the statute because the statute's unconstitutional. It's not particularly relevant in terms of how the case is ultimately resolved, but it's a somewhat unusual procedural posture that I just wanted you guys to be aware of. And that is different. It's different than taking the appellate route, right?
So is it like saying he doesn't have jurisdiction, or is it like a jurisdictional challenge?
Well, it goes to the power and authority of the judge in a way that a regular appeal doesn't.
Yeah.
Yeah. And why this was the preferred vehicle in this case, I have no idea. But it's just interesting to note that. And I passed out the table of contents from the Federal Rules of Appellate Procedure just to show you, this is still here, right? The Title V Extraordinary Writs. Okay, and this does come up sometimes. This will come up sometimes in your work. That a writ of prohibition or mandamus is
larger effect just because it's like it is being challenged like so facially and not as applied at all. Like, I mean, if he was convicted and they appealed it after he was convicted, like would it have less ranging?
And that was actually a question that popped into my mind as I was reading this. Is this a facial challenge?
Well, this comes up in
or an
ours too.
as-applied challenge?
No, so this is one of those categories that seems really clear cut, but it's not necessarily. So let's talk a little bit conceptually about what facial and as applied means, okay? So a facial challenge does not mean that you're kind of abstractly questioning the constitutionality of a particular statute because you wouldn't have standing and the issue wouldn't be right. So in both the facial challenge and the as applied challenge, the person has actually suffered a harm by virtue of enforcement of the statute, right? Or is going to soon suffer a harm by virtue of enforcement of the statute. So what's the difference between a facial challenge and an as applied challenge?
Isn't that a facial challenge would be, or if they succeed and prove the law is facially unconstitutional, it'd be unconstitutional as applied to anybody?
Yes, exactly.
And as applied is just in this particular circumstance?
And what's the difference in terms of the claim? So that's the sort of the consequence of it, but what's the difference in terms of the claim? What's the relevant evidence in each case?
Oh.
Well, if it's as applied, it'd be just your plaintiff. Like the evidence would be limited to your plaintiff's actual situation. And then if it's facial, wouldn't you have like studies or surveys or?
No,
No,
not
there's
necessarily.
no-
I
there's
get
no-
where you're going, but that's not necessarily the case. It's just what it says, okay? You were really looking in a sense at the four corners of the particular statute or piece of state action that's being challenged.
So there really isn't evidence. I mean, there is as far as what it does, but you don't present evidence.
The primary evidence is sort of the four corners of the
Yeah.
law, right, within the four corners of the law, right? Whereas as applied, and so it's a high standard to achieve that you have to show there's no conceivable constitutional application of the law, right? And that's why it becomes invalid presumptively in every single case the law is struck. Versus an as applied challenge, and this is kind of a bit speculative, but I would say the majority of constitutional law cases that I've read is that it's a facial challenge, right? As applied challenge, you're conceding that there might be some circumstances under which this law could be constitutionally applied, but as it happened in your case, it infringed on your right to equal protection, your First Amendment right, what have you, okay? And really, equal protection, equal protection cases where there are facial classifications are going to be facial challenges, right? Because we talked about this last time. There's a distinction between saying that a law has a discriminatory impact, which is a whole different set of legal standards, and saying it discriminates on its face and is invalid for that reason, okay? I'm trying to remember how we got onto that.
So other than proving kind of standing under facial, would there be almost no other factual, would the other facts hardly matter?
There are a lot of other facts that matter in terms of, well, this is kind of like, I guess, how Erwin Chemerinsky describes it. So it's not that discrimination is unconstitutional. It's that unjustified discrimination is unconstitutional. So the question is always, okay, you've identified that there's discrimination, is it justified? That opens up an entire other factual record in terms of proving or disproving that there's justification for the law. But in terms of the object of scrutiny, the object of scrutiny is the text of the law under a facial challenge, okay? Whether that's supported or not by permissible legislative objectives or what have you. So, what's the source of facts?
Our court record, right?
Keep throwing it out there. It's from Plessy's petition. Okay? So why is there no conflict over this? It's not a case where there's a conflict over what the record states. Why? Why is there no conflict over that?
Because the facts are undisputed.
It's a facial challenge, right? He's not saying I didn't violate the law. It's a challenge to the constitutional law itself, and it's a facial challenge, so it's not about the circumstances surrounding the enforcement of the law. Again, which is typical of a test case, that you're not going to have, Bowers versus Hardwick, you don't have, the defendant claiming he wasn't committing an act of sodomy or what have you, okay?
Can I just ask about
Of course.
the test case?
Yeah.
So how did the person who assigned people to cars know? Or like, how did the test case thing work?
Well, so one theory, and I don't know what happened historically as a matter of history, but one idea is that, Plessy announces, did you know, by the way, hey, I'm sitting here, did you know, by the way, that I'm 1/8 black? And then the conductor is trying to force him to move to the other car. Okay. Standard of review? Does the court say anything about its standard of review? It doesn't. Why? It's a legal issue. Okay, it's a pure legal issue, essentially. There's no, again, and just to try to point out, and this is, often the case, the standard of review is so important, So a lot of times the Supreme Court's not talking about it because the Supreme Court is really looking at, these pure sort of legal issues, right? Okay, but the standard of review here is de novo because the claim on appeal is limited to a pure legal issue of whether the statute is constitutional. Okay, so
How do they break down the standards at this point?
Oh, you mean at this point in time, whether the court had clearly articulated the different standards of review for?
Right, I mean,
I don't.
is Caroline's after.
Well, since the facts are.
Oh, levels of scrutiny, because that's different.
Yeah, I'm
so,
sorry.
No,
sorry.
it is confusing though, it is confusing. So standard of review is the standard of appellate
Sorry, I
review.
didn't
No,
know.
that's fine. And then levels of scrutiny is, strict scrutiny, intermediate scrutiny, and rational basis review. So no, the standards, in the levels of scrutiny were not really firmed up until quite a bit later, after Caroline products even. Okay, so what I would like to do now is to have you guys take a couple of minutes here, and I want you to draft a meta IRAC, which is a single sort of IRAC syllogism that encompasses the entire case. And I want you to write the one that represents the majority's reasoning, and then the one that represents the reasoning of the dissent.
2 items?
It's 2 IRACs.
Are we just writing this or putting it in email?
You don't have to do this in email, this is just to further our conversation. And if you're having trouble conceiving of the issue, one thing you can do is to focus on the rule, and then you can reverse engineer the issue from the rule. Okay?
Do you want an IRAC or a syllogism? Did you say syllogism?
So IRAC is syllogistic reasoning,
Right,
so
right.
yeah, write it as IRAC.
Okay.
Okay, but major premise, minor premise, conclusion, the same pieces, right? Okay, let's talk a little bit, even if you're not completely done. So just to make explicit my point about syllogistic reasoning, that, IRAC is essentially is a form of syllogistic reasoning. So you have a major premise, which is the rule or the standard, the minor premise, which is the specific facts of our case, not least a conclusion. So, I like, is Betty smart? All of them are smart. Here, Betty is a woman. Therefore, Betty is smart. What's wrong with this particular syllogism? You can say it, guys. Don't be afraid.
The major premise is wrong.
Why?
It's not grounded in truth.
Because not all women are smart. It's a stereotype, it's a generalization, right? And this is actually really pertinent to equal protection law, that if one of your major premises relies on a stereotype about a group of people, there's actually something, that's a major premise that then you have a basis for attacking, okay? But so, really, you can think of legal reasoning under IRAC analysis as just kind of falling into that classic pattern of syllogistic reasoning. Okay, so did anybody start with the rule? Did anybody sort of say, I'm not sure exactly how they were framing the issue, so I'm going to start with the rule? No. Okay. So what issue did you guys come up with?
Is separate but equal constitutional? Or in the alternative, does it violate? I mean, they talked about the 13th Amendment, but does it violate the 14th Amendment?
Okay. What rule did you come up with?
I said that it was constitutional. I just did really basic.
So do you see how that's
the Constitution?
So that issue and that rule don't actually totally walk together, right? It's really just a question and then an assertion of an answer. So we'll talk a little bit about that logical disconnect.
My issue is very generic. Is the segregation statute constitutional under the 13th, 14th?
Okay.
I framed this a lot more narrowly.
Okay.
I said whether a law requiring a railroad to provide separate areas for and enforce separations of different races violates the customer's 13th and 14th Amendment rights.
Okay.
I just said, is the statute constitutional?
Okay. Okay.
Mine's whether the Louisiana law dictates the unequal treatment of African Americans.
Interesting. Okay. Interesting. Let's try it this way. Those are all good. What is the rule of law that Plessy stands for? Famously.
Separate but equal. It's
Elaborate on that. Separate but equal is okay. What does that mean? It's okay.
Well, my rule of law is all men are equal before the law, and that the effect of segregation is to separate people, but it's still equal. So it fulfills the
requirement. Okay. So if where a law imposes separate but equal conditions on the basis of race, what's the end of that sentence? You said it's okay.
It's constitutional.
Okay.
When they're
More
equal.
precise.
Doesn't it depend on them being equal? Or
Yeah, there's such an assumption in that rule of law. It's
Yeah. But we're assuming, there was no contention here that the conditions were unequal, right? Same as in Brown versus Board of Education. There's no contention of inequality. It's the principle that's being attacked. What are the consequences for the Equal Protection Clause? Does it even apply according to the majority? Okay, so that's when you're saying it's okay. It's saying the Equal Protection Clause is not even implicated when you have separate but equal discrimination. Okay, so where law imposes separate but equal conditions on the basis of race, the Equal Protection Clause is not implicated. So what is that? What's your rule? I'm sorry, what's your issue then, if you work backwards from that? So the rule is the standard or principle that helps you answer the question posed by the issue. What's the question?
Is the law separate but equal?
Is the equal protection clause implicated
Yeah.
when there is a law that imposes separate but equal conditions on the basis of rights?
I have a.
So I'm gonna make the issue a little bit more specific to our facts. So is the equal protection clause implicated by a law that segregates train passengers? Okay, so here, you know, train compartments are, you know, equivalent. Now, there are other meta IRACs that you could do. This is just one of them, right? But this puts at the center, really, the rule of law that Plessy is known for, okay?
They purported to also be discussing due process and privileges and immunities, which this doesn't touch at all.
Yeah, that's what I wanted to
Go ahead.
ask you also. I was confused. I mean, I thought that they decided it based on equal protection, but I guess maybe, yeah, what, like substantive due process? I don't. I'm confused.
Okay. If the equal protection clause is not implicated, what consequence?
It's not unconstitutional.
No?
Rational basis review.
That's the consequence.
Decision.
Okay. So,
But even if it doesn't, what if it violates another part of the Constitution?
like,
For example, the whatever they
Well,
say,
obviously, you could
process
bring-
or immunities, so then
Mhm.
you would still get
Clause.
strict scrutiny, right? Or is it just with equal protection that?
Yeah.
Okay, so I don't know that much about the privileges and immunities clause. In terms of due process, when do you get strict scrutiny?
When you are a suspect class.
That's equal protection.
It's just a Louisiana law.
This is for substantive due process, right?
Yeah.
Okay, I don't know.
Federal right.
That's it.
Okay, otherwise, rational basis review. Okay.
Okay.
And what about, let's IRAC the 13th Amendment issue. Okay, so issue, is the 13th Amendment implicated? Rule, the 13th Amendment, I apologize for my handwriting, I haven't done my whole spiel about my handwriting yet, but it's illegible. Is the 13th Amendment is implicated when?
There's involuntary servitude.
What else? So obviously, yeah, when you have like slavery. What else?
It's a legal right to the disposal of person, property,
Okay.
Because they talk about how your reputation, which is somewhat premised on race, is considered your property.
Okay, that's the due process. Okay.
Oh, that's fortunate.
So this is great, I think. We're going to talk about this. Sort of you talked about there being lies at the center of this decision, right? And one of the lies, I think, at the center of this decision is that there is no meaning generated by this separation or segregation, right? That it's, you know, if there's any inference of inferiority, that's on the, you know, the shoulders of African Americans themselves. But in discussing, so the idea is that the property right is the property interest in whiteness, right? Okay. And then the court says that a colored person has no right to, he's not lawfully entitled to the reputation of being a white man.
I drew a sad face in the margin.
Okay, so I mean, it's sort of, there are these lines, there's a sort of self-contradiction, okay, about whether there is a significance in a hierarchical ordering, right, to distinguishing between people on the basis of race. So yeah, that, I mean, if you had to sort of trace the reasoning of this argument, plaintiff claims that he's being denied a property right, and that property right is the right and the reputation of being white. What does the court say in response? Doesn't really even actually address it whether it's a fundamental right, but it says, well, obviously, because you're not white, you're not entitled to it. So, end of discussion.
And they don't do they don't switch it around and do the opposite and say, it says, if you're a white man and you get assigned to the black car, you have lost your property just in your reputation as white. And if you're a colored man and you're assigned to the colored car, you're not deprived of anything because you have no right to. But they didn't do if you're a white man and you're, wait, I'm switching this. Yeah, I can get assigned to the white car. They didn't even think about the other side of the
because there's sort of this false equality, right, that the court is actually belying in multiple passages, right, that it doesn't actually pursue this equality. Getting back to the 13th Amendment argument, there's another trigger for 13th Amendment concerns the court mentions.
Is that when they say if this is a 13th Amendment claim, then anything relating to race is a 13th Amendment claim?
Okay, I wasn't thinking of that, but that's right. I mean, they have a sort of fear of an expansive reading of the 13th Amendment, right?
Mm-hmm. It's on page 1140 at the very bottom of the left column when it says it would be running the slavery question into the ground to make it apply to every act of discrimination which a person may see fit to meet as the guess he will entertain, whereas to the people he will take the most close to camera calling.
Go ahead.
They're basically saying that the statute only implies a legal distinction.
So that they're talking about the Equal Protection Clause. So we'll talk about how they treat the Equal Protection Clause and the meaning of the Equal Protection Clause. But one of the things I want to point out about their treatment of the 13th Amendment argument is the rhetoric. How would you describe the rhetoric in terms of how seriously they took this claim?
Dismissive.
Okay, right? So it's too clear for argument. We don't think that they're seriously asserting this this particular claim. If you agree with the rule that the 13th Amendment has to do with incidents of slavery and disposal of one's person, what about the application? Is disposal of one's person implicated here?
What does that mean?
What does it mean?
Disposal of
It's a very old-timey phrase. I guess it might not
I think it also
mean much to you guys.
services too. Like I think control over the fruits of your labor.
Labor and things like that
Yeah.
too. Okay. But what does the idea of disposal of one's person kind of get at?
Freedom to move around.
Okay, right. That's which is part of liberty. The concept of constitutional liberty is that you can comport your person the way that you wish to. Okay, is that implicated here? Yes.
Mm-hmm.
It is severely implicated, but the court doesn't see it, okay? So in terms of thinking about critiques of the reasoning, here, okay, we might agree that this is the proper rule for when the 13th Amendment is implicated, but we might not agree in the application that it's not implicated by the facts of this case, where people are, in a situation where they otherwise would have freedom of movement, are being confined on the basis of their race. Okay. So the turning now to the equal protection argument, what what is the court saying about the Equal Protection Clause and its scope and its meaning? I think it's pretty confusing, to be honest with you, but what do you guys see? So, the Equal Protection Clause is not implicated where you have mere segregation, okay? What else? What other distinctions does the court draw? So on 1140, it says a statute which applies merely a legal distinction between the white and colored races, distinction which is founded on the color of the two races, and which must always exist so long as white men are distinguished from the other race by color, has no tendency to destroy the legal equality of the two races or reestablish a state of involuntary servitude.
It's still under their 13th Amendment analysis, isn't it?
Yeah, that. So, and that's actually the idea of the 13th Amendment being applicable where it has a tendency to establish a particular social position for African Americans. But the idea of, what is the idea of legal equality that the court is addressing there? It talks about, again, later in discussing the scope of the Equal Protection Clause.
I mean,
Does that paragraph make sense to you? Does that sentence make sense to you?
they're distinguishing it from social equality.
Okay.
Or what did they call it? Something else to make it like
Yeah, political and social.
Yeah.
They did.
So what are these categories? Explain them to me. Let's map them out. So there's social equality.
I guess they're saying legal equality would be, I would say maybe as the kind of our political, I don't know if they consider them the same, but that you still have all the same rights protected by the Constitution, but social equality that they don't guarantee that's separate. I don't really know what.
Where does civil rights fall? When we talk about civil rights, what are we talking about?
It's
What are they
from, it's
thinking
from
about?
the government affecting you, not private actors, right?
Tell me more.
So it's like the idea of negative liberty that the Constitution or what, only prevents the government from inhibiting your rights.
It says this in paragraph 2 in the right column of 1140. States are forbidden from making or enforcing any law which abridges the privileges or immunities.
Okay. What are they talking about?
Or
there?
deprive.
Which of these categories is that?
I think legal.
Okay.
So almost everything later, I mean, like staying at a hotel or whatever would be social then. Right?
Okay. So, and what
Yeah.
was the prior controversy around those sort of private actors and common carriers and things like that?
That it wasn't a government actor, so the Constitution didn't apply to them.
Right, and so Congress tried to sort of wrap this into the protections of the Equal Protection Clause, and that was seen as beyond the scope of what the Equal Protection Clause actually authorized. Okay, so
Oh, they weren't talking about Commerce Clause there? I thought that's what they were talking about, like the interstate.
I thought they were really trying to protect from a commerce clause, to protect themselves from attack there.
Yeah, I thought they were talking about the internal commerce of the state, neither abridges the privileges and immunities. Oh, okay.
So did Pleasant raise the Commerce Clause argument here, or did the court just like bring that up on their own?
well, what would the Commerce Clause argument goes, so what is the nature of a Commerce Clause argument?
It inhibits interstate commerce.
Well, the state
What does the
law-
Commerce Clause do for the federal government, and then what does it do for the state government?
What if it's not interstate commerce, right?
Go ahead.
We thought it was sort of a dormant commerce clause.
Yeah,
Because you have
Oh, I love this
Louisiana making this law that could impede interstate commerce, so then it's unconstitutional because it's in the realm of the federal government.
Which I guess wasn't created till much later anyways. The Dormant Commerce Clause, right?
Well, it's sort of interpreted, right? So the Commerce Clause, how does that empower the federal government?
Allows them to make laws over the states.
Okay, and so this is the hook, right, for enacting. I mean, the Congress is not just permitted to create legislation about any issue that it chooses, right? It actually has to have some foundational authority for that. And so the Commerce Clause enables Congress to regulate interstate commerce. And so the argument is that private discrimination interferes with interstate commerce, right? And then what's the counter argument?
But if it's intrastate, then states are free to govern themselves.
Okay, so there has to be that interstate kind of connection for the federal Congress to be legitimately involved in regulating what's happening within states, okay? So, because of course the Constitution does not, by default apply to private actors, so this is a way of Congress trying to reach out and get involved in that. And that was seen as, the Equal Protection Clause as being prohibitive and not authorizing affirmative action by the Congress, okay? So, the claim is that this is what the Equal Protection Clause is concerned with. Legal equality will be an example of that.
The right to vote.
Okay, vote. What's the example?
Jury.
Jury. Okay. Jury service. And what falls into the category of social equality?
Just like individuals having the freedom to discriminate against other individuals.
Okay, right. So private actors being able to do this, right? And talk about marriage and education. Those are things, segregation of marriage and education at the time of Plessy, not a concern of the Equal Protection Clause. Where does this statute fall?
They put it in social.
Is there a problem with that?
Well, yeah, it's this common carrier, so it really.
It's not just that.
Well, you lose legal rights.
Who enacted the law? Okay? This is state action. And when you come around to the time of Brown versus Board of Education, one of the big points there is that education at that point had become this primary function of local government. Okay, and so the Brown court had no problem seeing state action there, but apparently, and I think this is one of the lies at the center of Plessy, right, is this idea that there's not state action here. I mean, the court talks about, the law can't eradicate sort of personal preferences of not associating with members of the other race. Okay, fine, but that's not the situation here.
Right, the law is forcing them into a.
The law is enforcing this segregation. Okay, but there's sort of this notion that if the law is somehow congruent with majority sentiments, that's permissible.
Yeah, it wasn't even like the railroad operators rule.
No, but you could almost misinterpret that reading their analysis, right? That it seems to be about allowing private actors to do what they want to do, but that's not what it's about at all. It's about a state criminal statute, which is the sort of, paradigm of state action that could implicate the Constitution.
And it may, it's like we're about to enter like the Lochner era, right?
Mm-hmm.
And all of this freedom to contract and everything, and it's like the railroad's screwed either way. Like if they don't enforce it,
right,
they get fined. If they enforce it wrongly, they get fined.
Mm-hmm.
Like the state, I almost wonder if you could have challenged it from the railroad's point of view more successfully with like the state's imposition on the business.
Well, that would bring to the fore the idea that there is state action here that's rather oppressive, not just on the individuals, but also on these companies. But that's really hidden in the sort of analysis that the Plessy majority gives you, okay? So that's another kind of central rule of law or concept that's driving the majority reasoning, is that the equal protection, well, it's a problem with the rule and the application. So the rule is that the Equal Protection Clause applies only to so-called legal equality, not social equality. And, you know, the evolved view that comes about later is that these things feed into each other. Right? So you can't have somehow socially subordinate a group and not think it's going to have political effects or effects on legal status. Right? Yeah.
Is there a way, and I think I'm coming back to like rational basis scrutiny here, is there a way to say that a statute has like no meaningful standard and so it fails rational basis review?
So that's, well, that could be an arbitrariness argument, or it could be the idea that it has too much discretion.
Okay.
And
so
that
can we
was
say
kind of
that
touched
here?
on here, but not in a really clear
Because
way.
to me, the absolute worst part about this is that there's some individual who works for the railroad who's having to partition people based on what that person perceives their race to be.
Right.
So,
and what information goes into that.
Exactly.
You know.
So I'm wondering if there would be a way to challenge it, like this statute being arbitrary because there's no meaningful standard to apply, or no way to discern how to even implement it.
Mm-hmm.
Is that kind of too attenuated?
No, I think that's a viable argument.
I'm thinking back, so when Professor Scales was teaching us these different standards of review, she gave us these Venn diagrams that were like statutes that were over-inclusive, and like the issue was a little circle, under-inclusive, not touching at all, like, no, you know,
so that's a little different. That's a little different than arbitrariness or, you know, excessive discretion type of argument. That goes to the level of scrutiny and whether the level of scrutiny is satisfied. So under strict scrutiny, you can't, you know, you can't rely on these generalizations, right? So I can't rely on the generalization that all women are smart in enacting a law. It's over-inclusive, okay? And possibly under-inclusive as well. If I only want to hire smart people, and I say, well, I'm only going to hire women, both over and under-inclusive, okay? But so there's a problem with the rule, and there's a problem, and maybe a more profound dishonesty in the application, right? Which is not seeing, and that's the passage that I was reading to you about that just kind of is confounding to me. A statute which applies merely a legal distinction has no tendency to destroy the legal equality. It's right, it kind of makes your brain hurt. But so that application, so the rule is problematic, and then the application where the court does not see the implications, that there's a state actor here, right, enforcing this in the most severe way, which is through the criminal laws. Okay.
Yeah, it's funny how it ends up as a social equality standard after reading that sentence.
Yeah, it really, I mean, it's even by their own standards, they're not necessarily inherently, you know, or internally consistent. So, this sort of lies at the center of Plessy. The idea that separate can be equal, the idea that separation or segregation has no meaning, that it carries no connotations for one's status in society, while the court is at the same time recognizing that whiteness is sort of, you know, the reputation of whiteness is sort of this wonderful thing that everybody would want to have. The sort of lie about the presence of state action and whether these are natural affinities expressing themselves versus the state coming in and using the heavy-handed club of the criminal law to enforce it. Also, and I think this is really critical with Bowers too, relying on an idea of social reality without citations. Right, go ahead. What do you do?
No, there was another place I put a sad face. I was talking about like the natural way of things or something like that. Like, the object of the amendment was undoubtedly to enforce, this is 14th Amendment, to enforce the absolute equality of the two races before the law. But in the nature of things, it could not have been intended to abolish distinctions based on color or to enforce social as distinguished from political equality.
Right.
Okay.
Right. And that's where I really love legal reasoning, because we're basing it always in either, you know, an evidentiary record or a legal precedent, which can be challenged, right? And when the court wanders off into speculation about the nature of things, that's a problem. So by default, our natural instincts will always be permeated by contemporary prejudices. So we can't stop that, but what we can stop is the idea that it's okay to rely on common sense or, you know, your interpretation of the nature of things in deciding a judicial opinion, deciding a legal issue. So what would be the main and maybe it actually goes to the other rule that we outlined, but the different approach by the dissent here. Which is kind of superficially racist, but I don't know that it's as racist as some people have argued that it is. But anyways, that's a topic for another time.
I didn't quite work all the way through it, but what I was kind of trying transition into is just like the separation itself, like challenging the separation itself as unequal, or
Separate's not equal because what?
Because you can't bring your nurse in the
Because there's an inherent, I don't know, that's not,
is this under the 13th Amendment? Is that where we're at?
No.
Well, because it implies inferiority.
Yes, okay, right. And he doesn't exactly explain how. You know, he says, we all know what this is really about. This is really about whites keeping blacks out because they think they're inferior. It implies this inferiority. It doesn't really explain how that power differential gets incorporated into, you know, the mere sort of act of separation. But that's really the point of disagreement between the majority and the dissent. Okay, I want to talk about Bowers for a few minutes. Let's do this as a group. Bowers versus Hardwick is just two of my favorite decisions. Bowers versus Hardwick and Claiborne, both written by Justice White.
Who's your favorite decision?
I just love Bowers. I think it's just so interesting as a piece of reasoning. So, it is very transparent, actually. What is the issue according to the majority in Bowers?
Is homosexual sodomy a fundamental right?
Fun right is my abbreviation for fundamental right. I should read the exact language. Find the exact language where the court says the issue is. So we're not deciding whether these laws are wise.
the issue presented is whether the federal constitution confers a fundamental right upon homosexuals to engage in sodomy and hence invalidates the laws of the many states that still make such conduct illegal and have done so for a very long time.
Do you have any sense of where the courts would come out after that? Right? So that's a great issue statement, actually. And I did look at the Constitution recently. I did not see a fundamental right to sodomy in there, surprisingly enough. Well, how does the dissent frame the issue? And ultimately, this is how Lawrence versus Texas frames the issue.
Doesn't they say consensual?
First of all, it takes out, I mean,
Right to privacy?
if you start to ask whether a particular group that happens to be quite disfavored has a right, there's already an issue there, right? So the dissent, and ultimately Lawrence versus Texas, is asking whether all people have, not conferred on them by the Constitution, but have, inherently themselves, a right to privacy and liberty in intimate relations.
And they're distinguishing because it's not just a homosexual issue, it could be a heterosexual issue.
Yeah. Both in terms of the definition of sodomy, sodomy is any type of non-procreative sex, and also in terms of the actual language of the statute, which does not distinguish. Unlike in Lawrence versus Texas, in Lawrence versus Texas, it was just about homosexual sodomy. The statute at issue here does not draw that distinction.
does not.
A right is fun if? If anyone needs to go, just stop me, okay? Just.
Are we thinking the history and tradition?
Okay, we're talking about history and tradition,
This is-
implicit in the concept of ordered liberty, to which I asked for whom. Because if you're homosexual, I kind of think that being able to engage in sex is maybe important to your sense of liberty, you know, but, and there's one more component. Yes, well, okay, we were in the history and tradition.
They have, I mean, part of test one kind of is neither liberty nor justice would exist if they were sacrificed.
Yes, okay. Which again, you know, what kind of rule of law is this? Is this, you know, concise, concrete, helpful? Right, there's a lot of subjective concepts in here. So, essentially the idea here is that the status quo is sort of guides us in terms of what's morally correct, what's correct in terms of justice. Is this rule sensitive to the rights of minorities? Right, so the other piece of this is the idea that majoritarian morality is a legitimate state interest, right? Which is not really particularly appropriate standard for the Equal Protection Clause, which is, you know, essentially counter-majoritarian imperative to the courts. So the, you know, but, and it's interesting because then, even if you apply the same rule, not this rule, but this rule, to the issue as framed by the dissent, the result is still different, right? This case is an excellent example of how the framing of the issue can really dictate the outcome or somehow function to justify the outcome of the case, okay? And we'll get to this when we start looking at the same-sex marriage problem, but is it fair to, this is what the courts are doing. The courts are not asking if there's a fundamental right to marriage. The courts are asking if there's a fundamental right to same-sex marriage. Is that problematic in a similar way to the framing of the issue by the majority in powers? Or is it not? Is it different somehow? So we'll get more into this later. I love Bill Eskridge's article. He has such a way with words. This was written,
I assume pretty soon after, but I couldn't find one.
I think it was a couple of years after the decision, maybe just within the next year after the decision. But first of all, talking about sodomy as a form of contraception, I thought was just hilarious. But you know, what does he do? I mean, he's outraged at this decision, but what he does is he carefully dissects their use of precedent, right? And that's one of the things I like about the Bauer decision, is sort of it uses analogy.